arrest of Richard M. Allen is sure a major step in leading to the conclusion of this long-term and complex investigation.
Shame on you! Shame on you, Richard! You're going to prison for the rest of your life!
It's a battle of the firearms experts as the unspent round from Richard Allen's gun has now become a focal point in the Delphi murders case. This as the defense is preparing to arrest. And a jury revealing new video of the New York subway chokehold case. The defendant telling officers, "I just put him out." So was this defense of others? Also this hour, we've got new developments to share with you in the case of Sandra Birchmore, a third officer linked sexually to the young woman before her untimely death. Plus, we're expecting a verdict today in the medical assisted murder trial as Quentin Nixon's pro se defense and his time on the stand is what's tipping the scales. It's all coming up next for you right here on Opening Statements. Good Wednesday morning to you and welcome to Opening Statements. I'm your host, Julie Grant. If you're new to the program, welcome. We're so glad you're here. I say it's like coffee and court. We get you all warmed up and ready to go for the big day ahead on Court TV Live. So why don't you go ahead and grab that cup of coffee. It's time now for my opening statement. The most dangerous time for a domestic violence victim is when they leave. Because that's when the batterer is losing control. Power and control, my friends, that is what domestic violence is all about. And it sure seems that burn victim Terry Lewis may have been caught in that dreadful cycle of abuse. According to South Carolina prosecutors who are going after her husband, Craig, Terry was violently beaten, raped, and lit on fire when she told Craig that she was leaving him. What's more, after her husband is arrested and charged, the judge gives him a surety bond and he's out of jail. The guy has a criminal record. He allegedly tortures his wife as a means of controlling her, allegedly tries to burn her alive, and then he gets a $100,000 surety bond. A surety bond meaning a bail bondsman can help him get out immediately. No, 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 no. On those allegations, that guy should have no bond, none. He should sit in jail and wait for his trial. Hopefully, make some nice friends on his cell block who don't condone beating a woman. Terry Lewis deserved to go find happiness. Terry Lewis deserved to be respected. She didn't deserve to be tortured within an inch of her life because she was taking control of her life. And my friends, we're going to find out during this trial if she was taking control back from her abuser too. That's my opening statement. As you can see, I'm fired up about this case. We're going to go there in our 9 a.m. hour. Now, what's coming up is your daily docket.
Bottom line, you're the one who shot Tony Westover, correct?
Yes, ma'am, in self-defense.
Okay, and you shot Tony with her own gun, correct?
Yes, ma'am.
Okay.
I didn't know it was her gun at the time, though.
In Ohio, we've got pro se defendant Quentin Nixon finding out the judge's verdict this morning in the shooting death over Tony Westover. Court starts up at 9 a.m. Eastern time. In South Carolina, we've got the state resuming its case. This is at 9:30 a.m. in the burned alive murder trial, the one I was just talking about, of defendant Craig Lewis, the victim Terry, his wife. And we've also got defendant Karen Reed expected to be in court today for a Supreme Court hearing in Massachusetts. This is an appeal that her attorneys have filed, and so we're going to be following that as well. Right now, let's go to our top story this morning, the Delphi murders case. The defense expecting to rest its case. They're representing Richard Allen, who's accused of murdering these beautiful young girls, 13-year-old Abby Williams and 14-year-old Libby German, back in February of 2017. Their bodies found near the Monon High Bridge Trail. The defense called Eric Warren, who's a firearms expert, to the stand in an effort to try to discredit the state's firearm expert's testimony about that unspent round that the state says cycled through Richard Allen's gun that was found at the crime scene. And the defense expert told the jury that the methods of testing that the state's expert used are simply unreliable. This expert said that because of pressure differences between fired and unfired rounds, comparisons should be apples to apples, not apples to oranges. Firearms expert Dutch Merrick, you know him and love him, friend of Court TV Network, gave us a demonstration about how an unspent round would leave markings.
When a gun is fired, there's a lot of pressure and energy, and that case is being beaten back and shot out very aggressively. When you're chambering a gun just with your hands, it's less energy and it's more passive. However, in both instances, they will leave some marks on the brass. This is not the same pistol. I didn't have access to a P226 this quickly. So this H&K USP will function very similarly. I'll take the magazine, put it in the grip, and when I chamber around, you can see it go from the magazine into the chamber. And then when it ejects, it pulls it out of the case and shoots it out. So inside the gun, you'll see this is the extractor rod that pulls out the case, and then the ejector rod is the one that pushes it off of the extractor. And it's important to note the base of the cartridge has a little notch here so that it can be grabbed by the extractor.
Here to discuss, criminal defense attorney and former prosecutor Franz Borghardt, private investigator and retired Army counterintelligence officer Manuel Gomez, and the co-host of the Deviant podcast, Andrew Iden, who also co-hosted the Down the Hill podcast with Court TV senior producer Barbara McDonald, who's on the ground for us on this case. Good morning to all of you gentlemen. Andrew, I want to go to you first, please. Knowing this story so well, or at least the story that was told prior to trial based on the filings from the prosecution, the defense, curious what your sense of the story is now.
Well, Julie, in the conversations I've had with people that were, close to this story in and around Delphi, there's a lot of feeling, I think, that if there's going to be a prosecution here, it's going to be, it may be difficult. There seems to be some sense that when they made the move to arrest Richard Allen and they released the probable cause of why they made that arrest, that it wasn't exactly strong. And, you mentioned the firearm testing yesterday. I'm no firearms expert, but if that's going to be the prosecution's main thing that gets this ball across the goal line to convict Richard Allen, I don't know how much progress they made yesterday. I'm still not sure that they made the argument that that's going to be, that piece of evidence has the level of importance that they originally thought.
Great points, Andrew. Let's dovetail off of what you just shared with us. Manuel Gomez, you are certainly adept at firearms. Curious what you make of this. Whose argument do you think the jury will give more weight to? The state's that he was there, his round, how did it get there unless somehow it was ejected from his gun? Or the defense argument that we can't trust that expert's testimony?
Well, I believe that the jury would most likely go towards the defense. And the reason why, again, is it's preponderous to think that you're going to base his conviction on a method that's not proven science. Measuring the markings of an extracted bullet is not accurate science. And this is a gun that, uses 4 different types of rounds. It fires the 9.19 parabellum round. It fires the 357 round. It fires the 22 long rifle round. And the reason why I'm familiar with this gun is because it's one of the guns used in the special forces, and I've used this personally in the military. So trying to base your case on this is this total insanity. And not only that, but throughout this whole case, it's been a travesty of justice. This man's rights have been violated numerous times. He's been confined for 13 months. His mind is out of it. And not only that, on top of that, what is the sense of having a gun, but you cut the girl's throats? No one has tied that together. So I think the defense will, made a strong case, and I think the jury will see that.
excellent points. I knew you'd be so knowledgeable about firearms, Manuel. Thank you for that. Let's talk more about the facts, the legal facts here in this case. Franz Borghardt, this is where I want to bring you in, please. So I want to show you some of the testimony from a witness named Betsy Blair. So this is a key crime scene witness for the state who says that she saw a car in the parking lot of the old CPS building the day that the girls disappear. She described the car as older, angular in shape, although she couldn't remember the color. According to a transcript from 2019, she told investigators it could have been black. Or not. Could not have been black. I'm sorry, could not have been black. I apologize, I don't have my glasses on, forgive me. Franz, some of this eyewitness testimony fits kind of, I guess you could say. It fits kind of. We know Alan puts himself there on the bridge. How much weight do you think the jury is going to give testimony like that from Betsy Blair and the others who see the man walking with the outfit that perhaps could have been Richard Allen's outfit on that day in question?
So the weight the jury is going to give is going to be contingent on, does the jury believe that the prosecutors are trying to fit a square peg in a round hole? Which is kind of the sense you've gotten throughout the entire trial, right? It's hey, we want you to rely on something that's not really reliable. If in fact they believe that the prosecution is kind of making a stretch or is trying to make something work that doesn't work, well, it's going to diminish the credibility of those witnesses. It doesn't mean that those witnesses are lying. It just means that they may not believe them to the same degree they would if they feel like the prosecution's being intellectually honest. We want to get the right guy. We want to get the murderer. But what we don't want to do is we don't want to force something that just doesn't fit. That's not the way our system works. So, you know, these you know, and plain language that the expert used applies across the case. Apples to apples, not apples to oranges. And that is the sense I think the jury is going to have is that the prosecution's looking at them and saying, hey, these are apples, and I want you to think of them as oranges. And I just don't think it's going to work.
Right, right. Really great points, Franz. And to go back to the car, I feel like we left out something really important here. The state is saying that Allen drove his 2016 black Ford Focus to the trail the day of the homicides. And so hearing this witness say it could not have been black in this transcript in 2019, where her memory would have been fresher, somewhat of a problem. Andrew Iden, let me go back to you because you know these facts like you know the back of your hand. Talk to us a little bit about the car and some of these discrepancies in the witness testimony, if you would.
Yeah, exactly. I mean, you know, that's a pretty big discrepancy. And, you know, Franz makes a good point about kind of trying to fit a square peg into a round hole. And the feeling and the sense that I've gotten kind of following this trial now into the third week is that seems like a sort of a pattern here where there is a piece of information or piece of evidence that, as you said, Julie, fits kinda. And I think that those two words are actually a perfect example and a perfect kind of metaphor for a lot of the evidence that the prosecution is laying out. It fits kinda. Well, fits kinda doesn't get you a conviction, right? And so I think that the defense, to some extent, is probably sitting back thinking, okay, if we let them continue here, the fits kinda is not going to get the job done.
Right, right, Andrew. And then if it is a fits kind of situation, Manuel, what happens then? If Richard Allen is not the guy, do you think these investigators are going to keep going and try to find someone else, or are they going to just hang their hat on this prosecution and say, well, we tried, this is who we believe is the guy, and let's say he's acquitted, leave it at that?
Well, unfortunately, if he is acquitted, and if he's acquitted, because I don't believe that the evidence they showed is beyond a reasonable doubt, and it's been pointed out here throughout this broadcast right now. But do I think that they're going to go pursue the guy who possibly did this? You know what? I would say 50-50. A lot of times cases like this, they become cold case files. And that's what been my experience in many states. They'll pursue it shortly for a few months and then it dies out. It's just a travesty of justice that none of these cops were prepared after 7.5 years of having this body, and they come in there unprepared. And it's a shame to the family and to the alleged perpetrator.
Right, it really is. And Franz, this jury could get this case this weekend, right? I mean, they could be deliberating. We know they've worked on the weekend. Legally, in your experience, how might that impact a verdict when jurors are going into, no doubt, their personal time?
So I don't like normally having juries getting the case on Fridays because they're more apt to make a quicker decision. However, there's enough for them to chew on. And you know, look, at the end of the day, even if they get the case in the weekend, it doesn't mean they have to rush, or they have, you know, the judge may say, hey, we're going to wait until next week. I'm always apprehensive, Julie, about getting a case at the end of the week, but that's just, I'm skittish like that. This jury, though, has reasonable doubt. If they choose to jump on it, if they choose to utilize it, I don't know that this will be an incredibly long deliberation.
Yeah, really great points, Franz. Thank you for that excellent insight from you all. We'll leave it here for now. Of course, our team is on the ground. We're to bring more updates from today when the defense could rest. We've got to say goodbye. And a big thank you to Andrew Iden. We'd love to have you back on the show, Andrew. I want everybody to check out your podcast, Deviant. And of course, go back and listen to the Down the Hill podcast as well. That's excellent, too. Thank you so much. Coming up next in What's Trending in True Crime. This is just awful. Jurors getting to see the newly released bystander video of the subway chokehold death in the trial of Daniel Penny. We'll talk about whether it was defense of others. And will another officer linked to Sandra Birchmore be decertified? That's also straight ahead.
Tonight on Court TV.
I'm Vinny Politan. Welcome to Closing Arguments. We have a big hour ahead here.
Your deplorable actions are unforgivable.
The community still doesn't know how this Boston police officer died.
He can't prove one element of his case. It was a dramatic day, a dramatic moment inside the courtroom.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan. Tonight at 8/7 Central. Only on Court TV.
Anything on him? Is that? You got anything on him? I don't know. I just put him out.
Now, for What's Trending in True Crime, the manslaughter trial for Marine veteran Daniel Penny is what is trending this morning as jurors are introduced to another angle of that subway chokehold that led to Jordan Neely's death. Notice her hand shaking in that video. So that was one of two videos shot by a bystander. And this offers the jury a direct view of the chokehold that's at the heart of this case against Daniel Penny. Now, this video is the second of those two shot by a freelance journalist. Prosecutors are alleging that Penny recklessly killed Jordan Neely because Neely had frightened passengers on that subway train. So what do you make of this encounter? Was this defense of others? Let's bring in our power panel and talk about it. I want to welcome in, still with me, criminal defense attorney and former prosecutor Franz Borchardt, private investigator and retired Army counterintelligence officer Manuel Gomez, and want to welcome in criminal defense attorney and civil rights attorney Casey Early. Great to have you all on this. Manuel, I want to go to you first on this one. with your law enforcement background, what do you see here when you look at the facts of this case?
Well, what I see here clearly is this is abuse of combat skills. I'm a retired military intelligence officer, and I'm trained in the same techniques that Daniel Perry used. And the chokehold he used is to kill, not to restrain. And the fact is that this case highlights a bigger problem that we have, because this is happening throughout U.S. bases all around, soldiers using their combat skills against people. And you have cases like Austin Hawke, Vanessa Guillen, and Ronald Valentin. I can go on and on. But this case highlights the need for sensitivity training. So to show soldiers that when you come back home, not to use these combat skills, but to use your skills to protect and save life. And this is the problem we have now. It's a national problem.
Great points, Manuel. Thank you for that. I have a clip from Jordan Neely's family's attorney, and you're all going to recognize him. He's a friend of the show, comes on regularly. Attorney Dante Mills is representing the Neely family civilly, and so of course he's watching this criminal case. Take a listen to some of what Dante said about the misconceptions about his client's loved one.
Who are we to look at someone and say they were houseless, so they must be a bad person? They were houseless, so they must have been about to attack us. They must have been about to hurt us. So we had the right to take his life because our life matters more.
Okay, Dante, they're just a little snippet from a press conference that he did on this one. Casey, early, I want to go to you next because you do civil rights work just as Dante Mills does. Your thoughts on this case, please.
Yeah, I have to agree with my colleague. This video was very difficult to watch. I don't see defensive force. I see a use of him showing and exerting his specialized training. And at what point did it not go off in his head that maybe this is too much? The train at that point had already stopped. He was in a chokehold for 6 minutes. There were other people there to help him subdue or restrain him. So the threat was no longer there. And I believe that there was reports that the person who was initially scared was nowhere in sight. So this is a very tragic situation because just as my colleague stated, I mean, they're trained for combat. This was not a combat situation. This was a disorderly conduct rather, at best, which is a misdemeanor, not a life sentence. So it's very tragic what happened, and the consequences will definitely be severe, especially with the civil rights portion.
Right. Yes, Casey. Franz Borghardt, want to go to you last, but certainly not least. I want to get your legal thoughts on this, being both a defense attorney and a former prosecutor.
So, defense of others is problematic in this case. Now, I like a diminished capacity argument. And we've already discussed it, right? We train these soldiers to be killers, but are we training them holistically to be sensitive to what's going on in non-combat situations? Did he snap? That to me seems more akin to what we have here. That all being said, I don't have subways where I'm at. So like, I've never ridden a subway where I felt in harm's way. So to the jury, can they put themselves in the shoes of the passengers? Can they put themselves in the shoes of the defendant? And I think that that's going to be problematic for the jurors as well. Is, look, this is the idea of detaining this individual of stopping a potential threat is all fine and good, but he puts a chokehold on him and he kills him. So I just don't know that this is a defendant that they are going to be able to identify with, even if they can identify with being in a subway in an awkward situation.
Sure. And look, no doubt that it was a jarring situation initially when there was yelling, apparently, according to the facts. And these are facts even Dante Mills will acknowledge. Look, so Jordan Neely dealt with some problems, right? He had mental health difficulties. He also, prosecutors have acknowledged, was high on synthetic marijuana at the time of this incident and came in yelling, ripped off his shirt, was saying doesn't care what happens. If he goes to jail, he's homeless, he's hungry. Some of those people were startled, but then the fact that that chokehold went on so long, this wasn't just to stop him from making any more threats or imminently, it just didn't stop. I think that is what is so stunning to me on this. But it's one thing to stop somebody from doing something imminent, but people were then screaming, it's like the tables turned and everybody was saying, let go, let go. So it's just horrible. And so what we want to focus on with this second aspect of this conversation is Jordan Neely's actions. And so I have a clip of the defendant, Daniel Penny, talking about the scene that he describes before placing, again, that mentally ill 30-year-old in that chokehold.
We were all scared. Mr. Neely was yelling in these passengers' faces, and they looked terrified. The reason why there was no video at the start of the altercation was because people were too afraid getting away from him. And the videos didn't start until they saw that situation was under control. I knew I had to act, and I acted in a way that would protect the other passengers, protect myself, and protect Mr. Neely. I used this hold to restrain him, and I did this by leaving my hand on top of his head to control his body. You can see in the video there's a clear rise and fall of his chest indicating that he was still breathing. And I'm calibrating my grip based on the force that he's exerting.
So how much did Jordan Neely's actions when he got on that subway, what he said, what he did, matter in deciding this case? Let's bring back in our power panel and talk about that. Manuel Gomez, I want to go back to you on this point. Your thoughts, please.
Well, right there, I'm sorry, but you see that Daniel Penny lied. He clearly lied because in the video, you see Jordan holding his hand up very gingerly to the other man, actually reaching out for help. And then you see his arm movement very slow. You can see one man grab his arm and then hold it down, and then he literally reaches up to the other man, almost asking for help. He was not in any way a threat at that moment. He should have been released at that moment, and this clearly shows that the abuse of force and the combat skills he used was lethal. He knew what he was doing. You could see him tap on the man's leg, almost asking for help, and the man reaches down and grabs his hand. And the bottom line is, he should be found guilty. This needs to be a wake-up call for America, that we have to have that training for our soldiers, that life is important.
Thank you for that, Manuel. Casey Early, want to go back to you. Your thoughts on this?
This is exactly why, from a criminal defense perspective, we tell our clients not to give any statement. Why are you trying to persuade the court of public opinion? Because now what you said is going to stick with you if you decide, and of course he would have to take the stand in this case because he's claiming defense of others. So why would you give a statement? Because first of all, that statement is not credible. I mean, it was just, the video is the best evidence, and it was inhumane. And even when officers arrive, he's just standing there nonchalant. So you're trying to subdue this victim. You realize this victim is dead or dying, and you don't apply or try to render aid. So all of his actions from the video is contrary to what he's saying. This was unnecessary, excessive force, and I agree, a guilty verdict.
Franz Borghardt, would you take us home? Your thoughts?
This is one where I would want to plead him if he was my client. You know, it kind of fits the textbook definition of a manslaughter, right? It's not going to be a very difficult case for the state. And as everyone has said, loose lips sink ships, and, making statements and comments. And look, I think he absolutely doesn't think he did anything wrong. And I don't think a jury is going to like that. A little bit of remorse, a little bit of regret of, hey, I'm terribly sorry this happened. I'm sorry I had to use this force, but I thought it was necessary. That would have gone so much further than just this I didn't do anything wrong, I'm not sorry kind of attitude. And I think he is going to be convicted, and I think this will send a message.
Franz, thank you. We will leave it there for now and, of course, continue monitoring this case. Our cameras are not allowed in the courtroom, but we'll keep everyone posted on any major details. I have to say goodbye and a big thank you to Manuel Gomez for all of his expertise this morning. Thank you, Manuel. Casey and Franz are coming along with us. Still ahead here on Opening Statements. We're spotlighting the death of Sandra Birchmore. Yet another officer may be decertified. We'll explain why. Plus, pro se defendant Quentin Nixon will be learning his fate today in the medical assistant murder trial.